Court calls the case, People versus Theophilus Smith.
Nicole Hughes on behalf of the people.
This case opens with immediate tension, and it doesn't take long to see why. What you're about to witness is not just a routine courtroom exchange. It's a collision between legal strategy, emotional instability, and a defendant who is actively working against his own defense. From the very first seconds, you can sense that control inside this courtroom is fragile. The judge, Judge Simpson, is trying to maintain structure. The defense attorney is trying to slow things down. And the defendant? He's already showing signs that he's not aligned with either of them. Now here's what makes this situation critical. In criminal proceedings, especially ones involving violent allegations, every word matters. Every interruption, every emotional outburst, every decision, it can directly impact the outcome. Never awareness, it gets thick. And what we're about to see is a defendant who doesn't fully grasp that reality. Pay attention to how early he starts asking for a breakout room, how quickly he expresses dissatisfaction with his attorney, and how the court responds. Because these small moments, they're not small at all. They are setting the stage for a major legal collapse. And here's the real question you need to keep in mind as this unfolds. Is this a man trying to defend himself, or a man unknowingly digging his own grave?
Edward Drukas on behalf of Theophilus Smith.
Mr. Smith, can you state your name, please?
Theophilus Smith. May I go in the breakout room with my attorney, Your Honor?
No.
Because I haven't.
Pardon?
Because I wanted to change some things I wanted to do. Me and him talked briefly, but I didn't get down to the A's and B's.
You didn't get down to what?
I wasn't able to tell my attorney exactly what I wanted him to do for me today.
Mr. Drukas,
Thank you, Your Honor. Actually, I did spend about 50 minutes with him here this morning. I did get the discovery. There are some video that I did start to go over with him. We also discussed some potential other video that may still be outstanding. And again, I was appointed yesterday. I'm looking to get an adjournment today, so I can fully go over the discovery with him and make a determination on what to do.
Probable cause conference in this matter, November 9th, 2023,
Did you address bond?
9 a.m. Excuse me?
Can my attorney address my bond?
This is where legal strategy starts clashing with emotion. The defense attorney is making a very calculated decision. Do not touch the bond right now. And that's not random. In cases involving alleged violence, especially with pending evidence like video footage, the prosecution is often waiting for an opportunity to push for a higher bond. And the moment the defense reopens that topic, it gives the prosecution exactly what they want, a chance to escalate. The defendant, however, doesn't see that bigger picture. He's focused on immediate relief, getting out, lowering the bond, gaining control. But courtroom strategy isn't about what you want right now. It's about minimizing damage long-term. And notice how the prosecutor immediately signals danger. If bond is addressed, they will push for an increase. That's not a warning, that's a setup. The defense hears it, the judge understands it. But the defendant, he keeps pushing. This is a textbook example of why legal representation matters. Your attorney isn't just speaking for you. They're protecting you from yourself. And here's the key question. If your lawyer tells you not to do something in court, and you do it anyway, who's really in control of your case?
Well, he knows how to do that, but yeah, go ahead, Mr. Drukas.
Mr. Smith, I had gone over that with you. With regard to right now, we're not going to be addressing bond.
No, but I did. Hold on, but I didn't want to. That's why I wanted to go into the breakout room so we could be on the same page.
I know. You don't need to go over this on the record, Mr. Smith.
Mr. Drukas, for the record, should defense counsel address bond, I will be asking the court to increase the defendant's bond. I understand why Mr. Drukas is making the decision he's making.
Okay, I understand. When is my next court day?
So are we done with the bond thing?
He ain't even address it.
Yes, Your Honor. I believe you had said November 9th.
Mr. Drukas?
Yes, Your Honor.
Do you want to address bond? He wants to address bond.
No, Your Honor. I'm asking for that SPC on November 9th.
Mr. Smith, the risk is if I address bond, I'm going to address all bond. I'm going to leave it where it is right now, but the people have made it clear that they're going to be asking for an increase. Your counsel is making a strategic decision not to address bond at this time, but if you wish bond be addressed, then...
No, I did not want to postpone my preliminary. I wanted my preliminary to be, I didn't want to post no more probable cause. I want to move towards the preliminary. I don't want to have another probable cause conference.
Have you looked
That's why me and my
over?
attorney,
Mr. Smith?
Simpson, don't do
Mr.
this to me.
Smith, did you listen to what your attorney said? There's video he still has to go through with you.
Yeah, but
So you want to have your preliminary examination before that happens? Because if I said it, I'm going to instruct the judge that not to adjourn it because you want to look at the video now.
To be clear for the record, the videos that we have turned over to defense counsel include the defendant brutally assaulting a victim. She was on the ground. He kicked her in the face repeatedly until she was left with what looked like a broken jaw to the police. She could not open her mouth and she could not speak, and she was rushed to the hospital.
This is the turning point. Up until now, this was procedural tension. Now it becomes something much heavier. The actual substance of the case. The prosecution just introduced a brutal description of the alleged assault, and more importantly, they referenced video evidence. In legal terms, that changes everything. Video evidence is one of the strongest forms of proof in court. It removes ambiguity, it reduces reliance on testimony, and it gives the prosecution a powerful narrative they can show, not just tell. That's why the defense attorney wanted more time. To review that footage, understand its context, and possibly find anything that could mitigate the damage. But the defendant? He's rejecting that delay. He wants to move forward immediately without fully understanding what's on those tapes. That's not confidence. That's risk. And the prosecutor makes it even clearer. If this goes forward now, the court will only see the worst version of events. The raw assault without any additional context. This is a strategic trap, and the defendant is walking straight into it. Ask yourself this: if there's evidence that could either help or destroy your case, would you rush into court without seeing it?
Defense counsel has requested an adjournment and requested that I look into whether there are additional videos leading up to the assault to help Mr. Smith explain to the court perhaps what happened leading up to that. I am more than happy to continue to a preliminary exam with the only evidence available being the brutal assault that this man committed on that woman. So, Your Honor, if we want to go to an exam, let's go, but I will not be getting those videos turned over before that exam date.
Hey, what do you folks want to do?
Breakout room with my attorney, Your Honor.
No, I already said no.
So
you wanted that, you already spoke to your attorney. Your attorney had a very clear picture as to what he wanted to do. You come here this morning, I think, changing things. And I just want, if you want it set for an exam, I'll give you an exam. I'm assuming that setting it for an exam, Mr. Drukas, that would be over your advice to him at this point.
That is correct, Your Honor. Mr. Smith, let's proceed to November 9th, and we'll continue to negotiate with the prosecutor.
no, I want to say it to the exam.
Okay, well, that's against my advice. Your Honor, we can have an exam
Ms.
date.
Hughes, ready to go to exam this Tuesday?
We will do everything we can to get the victim there, and hopefully,
All right.
given her injury, she's able to speak at that point.
All right. Well, we'll figure it out at that
Now, can
point.
we address
We'll start his exam.
Can we address?
We'll start his exam October 31st,
Can we address
2023, 9 a.m. That's before me. Oh, joy. All right. Mr. Drukas, I
Yes, Your
realize
Honor.
your client's pushing you over your advice. Do you want me to address bond?
No, Your Honor.
This is one of the most dangerous decisions a defendant can make, going directly against legal counsel in open court. The judge gives him a clear warning, not vague, not implied, direct. If bond is addressed, everything is on the table. That includes his criminal history, the severity of the allegations, and any risk factors the prosecution wants to highlight. And still, he says yes. Why is this so critical? Because bond hearings are not just about money, they are about risk assessment. The court evaluates whether the defendant is a danger to the public or a flight risk. And once that door is opened, the prosecution is allowed to present everything that supports a higher bond. The defense attorney tried to shield him from that, but now that protection is gone. This is no longer a controlled legal process. This is exposure. And the judge's tone shifts here. You can hear it. The patience is thinning. The warnings are done. From this point forward, the consequences are on the defendant. Key question: at what point does confidence turn into self-sabotage?
Mr. Smith, you want me to address bond?
Please, Your Honor.
Over your attorney's advice?
Yes.
Okay, go ahead. Tell me what you want me to know.
Your Honor, my name is Theophilus Smith. I'm paranoid schizophrenic type 1, 2, and 3, and bipolar type 1 and 2. I had a rough breaking up, Your Honor. I knew I should have called the law. I should have called the police when he was making all them.
I'm going to stop you right there, Mr. Smith. I don't want to go into the facts of this case.
No, just let me talk, Drukas. Please let me talk. It's between me and the judge.
This moment is critical and dangerous. The defendant has just been explicitly warned. Anything he says can and will be used against him. That's not a formality. That's a legal reality. And yet, he pushes forward anyway. This is where you see a complete breakdown of courtroom discipline. He starts attempting to explain the situation, hint at facts, justify his actions, all without guidance, all without structure, and most importantly, all on the record. In criminal law, unfiltered statements are a prosecutor's goldmine. They don't need to prove inconsistencies if the defendant creates them himself. They don't need to build a narrative if the defendant hands them one. And notice how both the judge and the attorney repeatedly try to stop him. That's not interruption, that's protection. But he interprets it as opposition. This is the psychological layer of courtroom drama. When a defendant believes they are helping their case, but are actually damaging it in real time. And here's the engagement point. If you were in that position, emotional, frustrated, desperate, would you stay silent, or would you try to explain yourself?
Well, you can't talk about the facts of the case.
Your Honor.
Mr. Smith.
Yes.
Just because you're going over the advice of counsel, I'm just going to advise you that anything you say can be used against you. You understand that?
Yes, Your Honor.
Okay. I've given you your warning and admonition. Go ahead.
Okay, Your Honor. Well, pertaining to the case.
And I'm going to stop you right there again, Mr. Smith. I'd prefer that you not speak about this case.
But I'm asking you to address bond, and you're not doing nothing I want you to do. So let me do what I have to do for myself. This for me, not for you.
I know. And we talked about this. This is about
I know,
you.
but guess what? You not listening to nothing I'm saying. I would rather have Lamus represent me. Lamus. Because you're not doing nothing I said. And me and you we wouldn't even on the same page. We wouldn't even on the same page before the meeting ended earlier. So just let me talk without you objecting to your own client. Can you let me
speak? Mr. Smith, you seem to know better. You go ahead.
Your Honor, the defendant made several death threats to me. Not the defendant, the accuser. I don't know how the accuser knocked on my apartment door.
And again, Mr. Smith, I'm going to reiterate that you should not be speaking about the facts of this case.
Okay, I'm not going to speak about the facts of the case.
Okay, thank you.
Your Honor, if you could please give me a personal reconduct bond. Your Honor, I'm not a flight risk. I'm going to be in court on Tuesday. If you can lower my bond or give me a PR, Your Honor, I won't speak about no more of the facts of the case until Tuesday. I'm going to respect Edward Drukas on that point that I won't speak on the case. But if you could just give me a PR bond or lower my bond, because my family is not wealthy, Your Honor. We are not wealthy, and I can't afford $50,000, no 10%. Your Honor, if you can please just give me a chance to give me a real lawyer. Give me a lawyer.
Real lawyer?
No, a lawyer. No, I don't mean. I'm not taking nothing away from Drukas. I'm not taking nothing away from Drukas, Your Honor. I just want to check.
Oh, okay.
I just want to be free, Your Honor, because I feel like I'm not even guilty of this. My grandfather got inside of me. My grandfather was talking to me. My grandfather.
Ms. Hughes, response to the motion to reduce bond.
Thank you, Your Honor.
Mr. Smith, before you go, Ms. Hughes, Mr. Smith,
Yes,
I
sir.
warned you. I warned you. I told your counsel that if you ask me to address bond, I'm going to address the whole thing. So maybe when Miss Hughes gets done, I haven't made a decision yet, but maybe when Miss Hughes gets done, this bond goes up. I gave you that warning and you went ahead. So now I'm going to let the people give their version. Go ahead, Miss Hughes.
Thank you, Your Honor. The people are requesting that this court set bond in the amount of $250 cash only. Notably here, the defendant's bond is $50,000 cash only. This is not even a cash surety case, never mind a 10%, which I think is pretty telling given how unique that type of bond is. The defendant is on misdemeanor probation for use of cocaine. It was initially charged as possession of cocaine, and it was pled down to use. At the time of his arraignment in this case, he was already in violation status of his misdemeanor probation. The defendant has a criminal history dating back, as far as I can see, to 2000, which includes a number of drug and alcohol misdemeanor offenses. He also has 6 assaultive felony convictions. In 2014, he was convicted of a couple of cases of R&O on the police. In 2019, he was convicted of felonious assault and CCW.
This is exactly what the warnings were about. The moment bond was reopened, the prosecution unleashes everything. Criminal history, prior convictions, probation violations, violent behavior patterns. This is not random information. This is structured argumentation designed to prove one thing, that the defendant is a danger to the public. And legally, this is devastating. When a court evaluates bond, past behavior is one of the strongest indicators of future risk. 6 assault-related felonies, that immediately shifts the perception from alleged incident to established pattern. Then add the details of this case, a severely injured victim, surveillance footage, lack of cooperation with police, and the argument becomes overwhelming. This is no longer about reducing bond. This is about justifying an increase. And remember, none of this would have been presented today if the bond issue had remained closed. This is the consequence of one decision. Question to consider: do you think the outcome here was avoidable or inevitable?
In this case, this occurred in Miller Manor inside the apartment building, and the apartment building has videos cameras, in the hallway. This case came to the police attention because a neighbor in Miller Manor heard yelling in a hallway. He exited his apartment, went into the hallway, and saw the defendant standing over a woman who had been brutally beat. She was laying on the apartment hallway floor, unable to get away from the defendant. The defendant then fled, went into his apartment. When the police arrived, they first tried to make contact with the defendant. He refused to open the door, refused to provide his name, refused to cooperate with the police. When the police made contact with the victim, her face was so damaged that she could not speak. She could not open her mouth. The police tried to interview her, and she could not even remain conscious. They were able to get her to agree to a medical release, and by the time they presented the medical release to her, she was no longer conscious to be able to sign it. The report indicates that she had injuries to her nose, to her cheeks, and to her jaw. She was immediately rushed to U of M. I am still waiting on her medical records to determine the extent of her injuries, but based on the police report, the police believe that her jaw was in fact broken, which is why her face was swollen and she was unable to speak. Again, Your Honor, our request is $250 cash only.
Anything else from the defense?
I think enough has been said, Your Honor. Nothing further.
Court believes, and the court would find that the setting of, under the circumstances of this case, that, and with all due respect to the magistrate, I understand what they were going through at the time, that the bond that is set at that time, the court would find that under the circumstances of this case, that may have been an abuse of discretion. The court will increase the defendant's bond in this matter, finding that the defendant is a risk to the public, a clear danger to the public given the circumstances of what the court has heard. Defendant's bond is increased in the amount of $2,000 or $200,000 cash surety. Thank you.
I'll come and see you, Mr. Smith.
This is the final result, and it's a direct reflection of everything that happened in this courtroom. The bond doesn't just increase, it quadruples, from $50,000 to $200,000 cash. That is a massive escalation, and it sends a clear message from the court. This defendant is considered a serious danger. Let's break this down professionally. The judge evaluated 3 key factors: the severity of the alleged crime, the defendant's criminal history, and his behavior in court. On all 3 fronts, the outcome worked against him. The violent nature of the allegations, combined with prior assault convictions, already placed him in a high-risk category. But what likely sealed it was his conduct: ignoring legal advice, speaking out of turn, and demonstrating instability during proceedings. The courts don't just assess past actions, they assess present behavior. And today, the defendant reinforced the prosecution's argument. This is a clear example of how courtroom decisions are not just about evidence. They're about perception, control, and strategy. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.